A machine shop in Milwaukee, an ordinary morning around 1910. A machinist in his early 30s is running a stamping press the same way he has run it 100 times before. For a fraction of a second his attention slips, or a piece of stock shifts wrong, and the machine catches his hand before he can pull it clear. Co-workers shut the power and pull him back. He survives. His hand and arm will not work the way they used to for a long time, maybe ever. He is married, with 2 young children at home, and until this morning his weekly wage was the entire financial structure holding that household together. The accident itself lasts only a few seconds. The paycheck it takes with it does not stop for seconds. It stops for weeks, possibly months, while the household keeps running on the same schedule it always did. Rent is still due on the first of the month. The grocer still expects to be paid. His children still need shoes before winter. The wage that held all of that together simply is not arriving anymore, and nobody has told him yet who is supposed to replace it. A modern viewer's instinct is to assume a claim gets filed, a case number gets assigned, and a check eventually arrives from an insurance fund built for exactly this situation. Set that instinct aside. An ordinary private industrial worker hurt on the job in 1910 had no such system waiting for him. A narrow federal law already covered certain hazardous federal jobs, and a few states were experimenting with reform, but nothing like a routine, predictable claim existed for a machinist in a private Milwaukee shop. That does not mean the law offered him nothing. It offered him something both more powerful and far less reliable than what exists today. It offered him the right to sue his employer. And if the story ended there, this would be a simple tale about lawsuits. It does not end there, because the law also handed the employer a set of tools that could make winning that lawsuit almost impossible, even when the injury was severe and the machine genuinely dangerous. To collect anything from his employer, the injured machinist could not simply point to his crushed hand and expect a payment. He had to file a negligence suit and prove, with witnesses and evidence, that the employer himself had done something wrong: unsafe equipment, inadequate guards on the machine, insufficient warning, careless supervision. An accident alone, however serious, was not automatically anyone's legal fault. Fault had to be established in court against an employer who had every incentive to argue that it had not been. Even if he could show the employer was careless, 3 long-standing legal defenses stood in his way, and each one could end the case by itself. The first was contributory negligence. If the court found that the machinist himself had contributed even slightly to the accident, a moment of inattention, a shortcut around a safety rule, the old rules of the era could let that alone defeat his entire claim, regardless of how negligent the employer had also been. The second was assumption of risk. Employers could argue that a known danger built into the job, the very way a stamping press was designed to operate, was a risk the worker had accepted the moment he agreed to run that machine for a wage. If the hazard was considered ordinary to the trade, the employer could claim the worker had effectively agreed in advance to bear the consequences of it himself. The third was the fellow servant rule. If a coworker's carelessness, rather than the employer's own decision, had caused or contributed to the accident, the employer could often escape liability entirely under this doctrine, even though the coworker had been hired, trained, supervised, and placed on that machine by the same company. The injured man's own workplace, in other words, could supply the employer's legal defense. Picture what that meant at the kitchen table. A lawyer explains what has to be proved. The employer's attorney raises one or more of the 3 defenses. Months pass while the case works through the courts, and during every one of those months, the wage is still gone and the bills are still arriving. The family is not simply waiting for justice. It is absorbing the cost of an accident, while the legal system slowly decides whether anyone besides the family will ever share that cost at all. A lawsuit like this also cost money and time the household frequently did not have. So many injured workers never filed one at all. Pursuing a case could mean months without any income, while legal fees accumulated against an uncertain outcome. So a family weighing a lawsuit against simply relying on savings, relatives, and whatever private aid was available was often making a real financial calculation, not a straightforward decision about principle. It would be wrong to describe this as a system with no upside for the worker at all. If he somehow proved negligence and defeated every defense the employer raised, the damages a court could award were not capped by any fixed schedule. A jury sympathetic to a severely injured man could grant him far more than any later compensation law would ever offer for the same injury. The old system was not simply worse for workers in every respect. It was a gamble with an uncertain but occasionally large payout, attached to a process that could just as easily leave him with nothing. So why did Americans tolerate a system that could leave a badly injured worker with nothing at all, even when the danger was obvious and the injury was real? The honest answer is that the old rule was not built out of cruelty. It was built around a coherent, older idea of individual responsibility, one that made a certain kind of sense before American industry reached the scale it had reached by the time this machinist went to work that morning. Under that older logic, an employer was not treated as the automatic insurer of every misfortune that happened on his property. Liability followed proven fault, the same as it would between two neighbors in an ordinary accident, because courts were built to weigh individual disputes between two named parties. A worker retained a real legal right to sue, and if he won, he could recover broadly. Many employers argued, not unreasonably by the standards of the time, that not every accident on a factory floor was actually caused by employer wrongdoing. That logic worked reasonably well when disputes stayed small. A single master craftsman, a single apprentice, one accident, one court case weighed on its own particular facts. Industrial America had stopped looking like that. Giant factories, mines, steel mills, and mass machinery had turned workplace injury from an occasional dispute between two people into a statistically predictable, recurring feature of running a large operation, with thousands of wage-dependent households exposed to the same category of risk at the same time. When injury becomes a routine, measurable cost of industrial production rather than an unusual event, treating every single case as its own isolated negligence dispute stops looking efficient or fair. Outcomes could vary sharply depending on the available evidence, which defenses an employer chose to raise, the jurisdiction, and the jury. So two households with nearly identical injuries could end up with very different results, decided less by the severity of the harm than by the strength of the legal fight around it. Industrialization had changed more than how many workers were being hurt. It had changed who actually had the resources to survive the wait for a verdict. A worker with savings, a strong union, or a generous employer might hold on through months of litigation. A worker without any of those things needed help long before a court ever ruled, and that meant someone, somewhere, was already paying for these injuries every single day, whether the law formally recognized it or not. That single fact, more than any moral argument about fairness, is what eventually turned industrial accidents from a private legal dispute into a public policy question. If the cost of injury was going to fall on someone, no matter what the courts decided, the practical question stopped being only whether the employer was guilty. It became who was best positioned to plan for, insure against, and spread a cost that industrial production was generating at a predictable rate every single year. Before any modern compensation system existed, the employer often bore only part of that total economic loss directly, and frequently far less than half of it. Much of the rest landed on the household itself, absorbing the loss through whatever private ladder of support it could reach. Savings went first, spent down within days or weeks. A brother or sister might take in the family for a while. A landlord might delay a rent payment, and a grocer might extend credit against wages that had not yet returned. Beyond the immediate family, a patchwork of voluntary institutions existed to catch some of what individual savings could not cover. A labor union with an out-of-work or accident fund might pay a modest weekly benefit to a member in good standing. A fraternal society, the kind millions of American workers paid dues to specifically for moments like this one, might offer similar support. Some employers maintained their own relief funds, and some carried liability insurance, a protection built primarily to cover the business against claims and lawsuits, not a guaranteed payment to the worker. None of this should be mistaken for a claim that nobody ever helped an injured worker before a formal government system existed. People did help, constantly, through exactly these private channels. But every one of those channels was uneven and conditional in a way a modern insurance claim is not, and when the patchwork ran short, families reached further still. Furniture or a wedding ring pawned for a few more weeks of rent, a wife taking in laundry, an older child leaving school to find whatever paid work was available. A worker with union membership, a considerate employer, savings, and a patient landlord could survive an injury far better than another worker, with the identical physical damage but none of those private advantages behind him. The factory itself typically lost one worker for a period of weeks. The family could lose its entire income structure for months, with no guarantee that any layer of this private safety net would hold the whole way down. Once reformers began actually measuring that hidden cost instead of simply describing it in general terms, the industrial accident stopped looking like a private misfortune between one man and one machine. It started looking like a recurring, quantifiable economic risk that industrial production itself was generating, a cost that had to land somewhere in the economy whether or not any court ever assigned legal blame for it. Beginning around 1907, investigators connected to a major study of industrial life in Pittsburgh, funded by the Russell Sage Foundation, set out to measure exactly that. Among them was a young attorney named Crystal Eastman, who focused specifically on workplace fatalities and injuries across one representative industrial district over the course of a full year, tracking not just how people died and were hurt at work, but who ultimately paid for it afterward. Her findings, published in 1910 as Work Accidents and the Law, documented hundreds of workplace deaths in that single district within a single year, along with a much larger number of serious injuries. Later accounts of her research put the toll at roughly 526 workplace deaths in that one industrial county alone over 12 months, a number large enough that a city of that size could no longer plausibly treat each fatality as an isolated, unrelated misfortune. The investigation asked a deliberately narrow, deliberately practical question, stripped of moral language, after a wage earner was disabled or killed on the job, whose household absorbed the resulting financial loss, and how much of that loss, if any, the responsible employer actually paid. The pattern her research exposed was consistent and damning in its plainness. Employers paid for only a small share of the economic cost created by these accidents. The rest fell onto injured workers, onto widows and children left without a breadwinner, onto private charity, and onto whatever family network happened to be nearby. Industrial production was generating a large, predictable, ongoing economic cost, and the existing legal system was routing most of that cost away from the industry that had created it in the first place. Eastman's work impressed New York's governor enough that he appointed her, still in her 20s, to a new state commission investigating employer liability for industrial accidents, where she helped draft an early version of a workers' compensation law for New York. The reform idea taking shape through commissions like hers in New York, Wisconsin, and elsewhere was not simply to make it easier to prove an employer negligent in more cases. It was something more fundamental, to make fault itself far less central to whether an injured worker received anything at all. That is the conceptual hinge on which this entire story turns. Instead of asking a court to weigh blame in every individual case, a compensation system would ask a much narrower, more mechanical question: did this injury happen in the course of covered work? If so, a defined benefit would be paid, according to a fixed schedule, regardless of whose carelessness, if anyone's, had actually caused the accident. But a plan that elegant immediately ran into a much harder question. Could a state legally force an employer to pay for an injury without proving that employer had done anything wrong? A limited federal answer already existed by 1908, when Congress passed a compensation law covering certain civilian federal employees in unusually hazardous work, such as laborers in government arsenals and manufacturing facilities. It was real, and it mattered to the workers it covered, but it was narrow by design, reaching only a fraction of the federal workforce in specific dangerous trades. It solved nothing for the millions of private industrial workers, including the machinist in Milwaukee, who worked for no branch of the federal government at all. Several states, including New York, had begun setting up commissions to study the question around 1909, and the results of those investigations, echoing what Eastman had already documented in Pittsburgh, generally found that a striking number of employers themselves favored some form of compensation reform over the uncertainty of ongoing negligence litigation. New York moved first among the states to act on that research, passing a compulsory compensation law in 1910 covering certain dangerous trades. That New York law lasted barely a year before it collided directly with the Constitution. In March of 1911, the state's highest court struck it down, ruling that forcing an employer to pay an injured worker without any proof of fault amounted to taking the employer's property without due process of law. The idea made economic sense to the reformers who had studied the problem. The court's answer was that a state could not simply order this exchange onto both sides by statute, no matter how sound the underlying policy reasoning happened to be. That defeat mattered enormously, because it proved the compensation idea was not yet legally secure anywhere in the country, no matter how many commissions had endorsed it on paper. A state could study the problem for years, draft careful legislation, and still watch the entire structure collapse in a single court ruling. If workers' compensation was going to survive as durable American law, someone was going to have to design a version that a court would actually uphold, not merely one that reformers considered fair. The timing made the defeat feel even sharper than the ruling alone would have. The very next day, a fire tore through a garment factory in New York City and killed well over 100 workers, trapped behind locked doors, a tragedy that had nothing directly to do with the compensation reform movement Eastman and others had already been building for years, but that intensified public pressure for workplace reform of every kind almost overnight, at the exact moment the compensation model had just been ruled unconstitutional. Wisconsin supplied that design only weeks later. In May of 1911, the state enacted its own Workmen's Compensation Act, built around the same no-fault principle New York had attempted, but with one critical difference in its architecture. Wisconsin's system was structured as elective rather than strictly compulsory, giving employers a real choice to participate rather than simply imposing the new liability on them outright. That voluntary structure became a major reason Wisconsin's own courts upheld the law against the same kind of constitutional challenge that had just destroyed New York's compulsory version. The law took full effect that September, and an entirely new kind of business appeared almost immediately to serve it. A small group of Wisconsin businessmen organized a mutual insurance company specifically to cover employers under the new statute, and its very first policy went to a paper mill in the small city of Wausau. Within months, this new state law had created not just a legal remedy for injured workers, but a new insurance industry built to price and spread the risk the old lawsuit system had left entirely uninsured. Return to the injured machinist, because this is the moment his situation actually changes. Under the older system, his questions had been legal and adversarial. Can I prove my employer was negligent? Can I defeat whichever of the three defenses gets raised against me? Can my family survive financially until a court finally issues a verdict? Under the new Wisconsin-style model, for a covered injury, the questions become something closer to administrative. Did this injury happen in the course of his covered employment? And what medical treatment, wage loss payment, or disability benefit does the statute say is owed to him? The exchange embedded in that shift deserves to be stated plainly, because it is the intellectual center of this entire story. The worker gained something valuable. He no longer had to prove ordinary employer negligence to receive anything, and the old defenses that had defeated so many claims before lost most of their power inside this new compensation process. In return, he generally gave up his ordinary path to an unlimited jury verdict for that same covered injury, including the kind of open-ended damages, such as compensation for pain and suffering, that a successful lawsuit could theoretically have delivered. The employer's side of that same exchange is just as important, and it is the part a modern viewer is least likely to expect. In return for accepting no-fault liability for every covered injury, even ones caused entirely by simple bad luck, the employer gave up the ability to escape payment entirely through contributory negligence, assumption of risk, or the fellow servant rule. What the employer gained back was predictability, an insurable, scheduled cost per injury, instead of an open-ended and occasionally catastrophic jury verdict that no accountant could reliably plan around from one year to the next. This is why the strange part of the story is not that reformers wanted this system. It is that a meaningful number of employers wanted it too. State commission investigations around this period repeatedly found substantial, though never universal, employer support for compensation reform, not out of sudden generosity, but because unpredictable negligence litigation had its own real costs: legal fees, unpredictable jury sympathy, and no reliable way to price the risk of running a factory from one year to the next. An employer facing that uncertainty could not simply set aside a fixed sum each year to cover industrial accidents, because there was no way to know in advance whether the next serious injury would settle quietly for a few $100s or turn into a runaway verdict worth many years of a worker's wages. A scheduled compensation system, backed by insurance priced against a known and stable risk, converted that unpredictable threat into an ordinary, budgetable cost of doing business, the same way a company might budget for the cost of raw materials or machine maintenance. State investigating commissions, gathering testimony from employers directly rather than guessing at their preferences, repeatedly reported this same finding back to their legislatures. A substantial share of the businessmen they interviewed preferred a known, scheduled liability to the growing uncertainty of jury verdicts that seemed, in the commission's own accounts, to be trending steadily larger and more sympathetic to injured workers with each passing year. It would be inaccurate to claim that every employer in the country welcomed this new liability, just as it would be inaccurate to claim that every employer had opposed the older negligence system. Support and resistance both existed, varying by industry, by state, and by how exposed a particular business already was to serious litigation. What the surviving evidence supports is narrower and still remarkable. Enough employers found predictable, scheduled liability preferable to unpredictable lawsuits that workers' compensation spread rapidly once a legally durable model like Wisconsin's had finally been demonstrated. A bargain making sound economic sense to both sides did not automatically make it constitutional everywhere, and New York's defeat in 1911 proved that courts could still dismantle even a well-designed compensation system. New York rewrote its own compulsory law after that defeat, and in 1917 the United States Supreme Court finally settled the larger constitutional question in a case involving a New York railroad watchman, Jacob White, who had died in the course of his employment. His widow filed a claim under New York's rewritten compensation law rather than pursuing an ordinary negligence lawsuit, and the railroad challenged the law itself, arguing all the way to the Supreme Court that being forced to pay compensation without any proof of its own fault amounted to an unconstitutional taking of company property. It was, in effect, the same argument that had already killed New York's first compensation law 6 years earlier. Now being tested at the highest level the American legal system had. The court's answer was unanimous, and for the compensation movement, decisive. States could constitutionally replace the old common law rules with a no-fault statutory system, so long as it gave both sides a reasonably just substitute for the rights being traded away, a fair process rather than an identical one. What had nearly been destroyed by one state court in 1911 was now affirmed by the nation's highest court only 6 years later, this time with no ambiguity left standing over its constitutional foundation. Once that legal question was settled, adoption spread with striking speed. 9 states beyond Wisconsin had already passed their own compensation laws that same year, 1911, and the pace continued through the following decade. According to the U.S. Department of Labor's own historical account of this period, by 1921, 46 separate American jurisdictions, covering the overwhelming majority of the country, had workmen's compensation laws in force. In roughly a single decade, a legal model that a court had ruled unconstitutional in one state had become the accepted national standard almost everywhere else. The speed of that spread did not mean every state adopted an identical statute. Coal mining states wrote schedules around the specific hazards of underground work. Manufacturing states like Wisconsin and New York shaped their laws around factory floors and stamping presses. A construction worker, a miner, and a machinist might all technically be covered by workers' compensation within the same decade, yet still face meaningfully different benefit schedules and waiting periods depending on which state happened to employ them. By the early 1920s, then, America had largely accepted the underlying idea that fault should no longer be the gateway to every payment after a workplace injury. But the systems actually delivering on that idea were not the single, uniform, comprehensive protection a modern viewer might picture when hearing the phrase workers' compensation. Coverage rules, benefit schedules, waiting periods, and administration all still varied meaningfully from one state to the next because this had never become one federal program. It had become nearly 50 separate state answers to the same underlying national problem. Some categories of workers remained excluded or fell under separate arrangements entirely. Certain interstate railroad employees, for instance, continued to operate under a different federal liability framework rather than an ordinary state compensation system, a complication this particular story has deliberately avoided by keeping its own illustrative worker inside an ordinary Milwaukee machine shop rather than a railroad. Federal civilian employees, meanwhile, remained under their own separate federal compensation law entirely, expanded in 1916 to finally cover the rest of the federal workforce the narrow 1908 statute had left out. Benefits under these new state systems were also generally partial rather than a full replacement of everything a seriously injured worker had actually lost. A scheduled wage loss payment was not the same as a full salary, and a fixed disability benefit under a state statute was rarely equivalent to what an exceptional jury verdict, one under the old system, might once have delivered to a small number of fortunate plaintiffs. The new bargain had genuinely traded away part of that upside in exchange for making some payment far more likely and far more predictable for everyone else. The legal fight over workplace injury did not disappear with this new system, it simply moved to a different, narrower battlefield. Before compensation, the central courtroom question had been whether the employer was negligent. After compensation, the recurring disputes became whether a particular injury had actually arisen out of and in the course of covered employment, and exactly how much wage loss or disability benefit the statute required an employer or insurer to pay in that specific case. It is also worth being precise about what this system was never designed to do. It answered who pays after a covered injury, not how to prevent one. It was not a workplace safety law, and it did not by itself make American factories safer. Broader safety regulation, inspecting hazards before an injury occurred, developed later through separate institutions built for that different purpose. Pricing injuries through insurance premiums may have nudged some employers toward safer equipment, but that was a side effect, not the design. Put the injured machinist back at that same kitchen table one final time. Before this durable state compensation model existed, he depended on savings, relatives, a landlord's patience, a union or fraternal fund if he belonged to one, and on a lawyer willing to gamble on a negligence lawsuit he could easily lose to contributory negligence, assumption of risk, or the fellow servant rule. He could win a large verdict, or he could win nothing at all for an identical injury. Under a covered claim after 1911, fault was no longer the gateway standing between him and any payment. He could expect defined medical treatment, a portion of his lost wages, and a scheduled disability benefit through an administrative claim rather than a courtroom battle, likely smaller than the rare jury verdict. The old system occasionally paid, but no longer dependent on proving his employer guilty or surviving 3 defenses built to defeat him. This system never eliminated the factory accident itself, and it never claimed to. It did not make every injured worker financially whole again, and it did not make every American employer guilty of wrongdoing simply for having a machine on the premises that could hurt someone. It did not create one single, identical national program covering every worker in exactly the same way from Wisconsin to Georgia. What it changed, precisely and permanently, was the underlying legal bargain that decided who paid, and how quickly, once the machine had already stopped and the wage had already gone silent. America did not eliminate the workplace accident in 1911. It changed the contract that followed one. The worker gave up much of his old chance at an unlimited jury verdict for a covered injury. The employer gave up much of his old chance to pay nothing at all. Neither side got everything it might once have hoped for, and that, in the end, was the entire point of the bargain both of them had finally been persuaded to accept.